with that and shift our focus to some breaking news coming in at this point of time. The Supreme Court has given a big verdict on dissolution of marriage. The Supreme Court has fast-tracked divorce in if irrevocably broken down the marriages, and the Supreme Court has said that it have inherent powers to give direct divorce. Till now, couples wait 6 to 18 months in family court, and this order applies to totally unworkable and beyond salvage marriage. My colleague Harish is joining us on the phone line to give us more details. Harish, the top court has given its big verdict on dissolution of marriages. Help us understand the entire matter here.
Yes, in fact, in a way, Supreme Court has fast-tracked the divorce in irretrievably broken down marriages, and Supreme Court has, the Constitution bench has ruled that it has inherent powers to give direct divorce. And remember, till now, couples had to wait from a period 6 months to 18 months in a family court, and now this applies to totally unworkable, beyond salvage marriages. Supreme Court Constitution bench, in a very significant landmark judgment, has ruled that it can exercise its inherent power under Article 142 of the Constitution to dissolve a marriage on the ground of irretrievable breakdown that is totally unworkable, emotionally dead, and beyond salvage. And Supreme Court has held that held that this court can dissolve marriage on the ground of irretrievable breakdown of marriage. We have also laid down factors which can determine when there will be irretrievable breakdown of marriage. We have held that the period of 6 months can be dispensed with subject to conditions laid down in the two previous judgments of the Supreme Court. So essentially, court has held that it can do so without, it can dissolve the marriage without referring parties to a family court where they must wait for around up to from 6 months to 18 months for a decree by mutual consent. Supreme Court held that continuing in a marriage which has broken down irretrievably amounts to cruelty, which is a for divorce under Hindu Marriage Act. Remember, Section 13 of the Hindu Marriage Act provides the procedure to obtain a divorce by when both the parties in a marriage consent. The parties must first approach the family court to initiate divorce proceedings. So now this has been dispensed with. So Supreme Court has very significantly said that in cases where there is an irretrievably broken down marriage, Supreme Court has inherent powers to give speedy relief to the couple, and they can approach the Supreme Court directly, and under 142, the Supreme Court, Article 142, Supreme Court can dissolve the marriage. As till now, why is it important is because till now couples had to wait in a period ranging from 6 months to 18 months in a family court, and this judgment applies to totally unworkable, beyond salvage marriages. Back to you.